I am the director of the Entrepreneurial Law Clinic, and I'm here with my colleague, Ron Lazebnik, who directs our Intellectual Property and Information Law Clinic. We are both professors in the law school who work closely with students to supervise them as they provide legal advice to entrepreneurs as well as other types of people who need legal assistance. And so we're really happy to be here today to do this legal workshop for the Fordham Foundry. It's our very first time doing it via Zoom, so we hope all will go well. I did have the chance to watch the pitch contest, and I really enjoyed watching that via Zoom. So we're happy that we can now complement that with the legal tutorial today. We're also joined by one of my advisory board members, Alexis Clemish, who is a member of the Entrepreneurial Law Advisory Council, as well as a member of Fordham University's Board of Trustees. So thank you so much, Alexis, for joining us. And of course, feel free to jump in if you have any thoughts or comments during the discussion today.
Thanks so much, Bernice.
Okay, great. The plan today is we have 5 key legal topics that we would like to cover. My students are going to be presenting to you on those issues. We really want to try to make this interactive. I know it can be challenging in the online format to have interaction. So we do encourage you, if you have any questions as my students are talking, please feel free to put those into the chat box and we'll try to address those as we go. And we also will leave plenty of time at the end for a Q&A session. In my experience, having done this many times, students often have a lot of questions during the Q&A session. So we hope you have questions. We're happy to answer those. And Professor Lazebnik, our intellectual property expert, is here to assist with the IP related questions. Also, as Albert Tosic just mentioned, this Zoom session is being recorded since some of the people who wanted to attend were not able to attend today. So please keep that in mind during the session as well. Okay, so without further ado, I will go ahead and turn it over to my students. One of my students will be controlling a PowerPoint that we've prepared for today. And I will now turn it over to Greg to get us started.
Great, thank you, Professor. So thanks everybody for joining us today. Like, we'd obviously preferred to have met you in person, but we're happy to do this legal workshop for you all via Zoom, just like you did your pitch contest. So I'm Greg Crisatello, and along with the fellow legal interns who will be speaking with you today, we're all third-year law students in the Entrepreneurial Law Clinic, which is a clinic at Fordham Law School that provides legal advice to entrepreneurs that are clients of the clinic, as well as community legal education, such as this for non-clients, which we'll explain on this next slide. So we are joined by Professor Grant, as she mentioned, as well as Professor Lazebnik, who's the director of the IP and Information Law Clinic, and they'll be available for any questions you may have. We want you to please note that this is for educational purposes only. It is not legal advice because you are not clients of our clinic and we do not know your specific situation. But since all of you recently took part in the pitch challenge, our goal is to teach you a few things about how the law can help you and make you more aware of how legal issues can affect your business as you continue to develop it. And we'll provide some helpful resources at the end of our presentation if you'd like to learn more. So today we're going to be covering 5 topics. And as Professor Grant mentioned, because this is virtual, it's a bit difficult to have an interactive presentation. So we'd love for you guys to use the chat feature or raise your hand in on the sidebar so you can chime in if you have any questions. We'll spend a maximum of 10 minutes per topic, so that'll take us to around 6 p.m. and we'll have that time at the end for question and answer. You've decided to launch into a new venture, so you have to think about what are some of the key legal issues you should consider and why does it matter. So today we'll be discussing co-founder relationships, choosing a name and protecting your intellectual property, liability protection, growing workforce while cash-strapped, as well as financing. So it's important to ask yourself, why do these matter? But they matter because it's important to set a good legal foundation for your business. There are some legal issues that if you don't address properly up front, they can really kill your company. So you need to protect yourself from liability and your company from competitors. It also allows you to use the law as a strategic tool to make your business more successful. So we'll provide an overview of these top 5 legal issues shown on screen, but we'll only have time to really scratch the surface today, but this will be a very helpful overview for you all. So the first topic is co-founder relationships. So I guess you guys can do a show of hands, or if you want to raise your little hand on the side, how many of you have a co-founder or are thinking of getting a co-founder? So many entrepreneurs launch their business with a co-founder, and we'll discuss some important things to keep in mind about how to manage this co-founder relationship. So what's the first problem with co-founders? Co-founders often don't discuss important issues up front, which can lead to disputes or even the failure of the company later. It's also fairly common for at least one co-founder to leave a startup in the early stages. So to address this, co-founders can enter into a document called a founder's agreement. This founder's agreement is a contract that companies' founders enter into that governs their business relationship. And that's where this prenup term comes in. So it's kind of like a prenup for your business marriage. So it's really important to talk about these founders' agreements and spell out these relationships of the co-founders at an early stage. So if you've already formed a legal entity, you would not use a founder's agreement, but you would instead address these points in the governing document, such as an operating agreement for your limited liability company or a shareholders agreement for a corporation. But if you're not that far, you can address these issues in this founder's agreement. But regardless of the name of the document, it's really important for you all to address these issues up front and really have these difficult conversations. So that leads us into this next point. You really need to have these difficult conversations among your co-founders. Answering these hard questions now will help you avoid conflicts later. The goal is to have an open and honest discussion about the attitudes, fears, and aspirations of the co-founders to avoid surprises later as the company grows. So this slide lists some of the topics to discuss. The theme of these questions is, what are each co-founder's rights, responsibilities, and obligations? So you could look through these. It's difficult to address some of these at the forefront because you're not always 100% sure, but it'll really make everything worthwhile if you can. And for more suggestions on these questions, you could check out Questions to Aid a Conversation Among Co-Founders page of the Founders Agreement section of the Penn Law Startup Kit, which is available on the Fordham Foundry website under the Entrepreneurial Toolkit tab, or you can just Google the Penn Law Startup Kit, which is a really helpful guide for you that can walk you through some of these difficult questions up front so that you can be a lot better prepared than you would have been. So the next discussion that you have to have among your co-founders is equity. So one of the main reasons for a founder's agreement is to avoid disputes later about who owns the business. So if any of you have seen the Social Network movie, you know that this was an issue with Facebook. So it's great to have these discussions before you run into these big problems with a successful company such as Facebook. So the first question is, what is equity? Equity basically means ownership of the company. For example, in a corporation, equity is called stock, and in an LLC, it's called membership interests. So your first question should be, how do you divide the equity? Do you do it equally? If you have two co-founders, they might want to split it equally 50-50. But that creates the risk of deadlocks, which means that if you can't agree on an important business decision, you need to have special deadlock provisions, or you're going to have to find a way to make this decision if it's 50-50 and you can't agree. So that's one of the real benefits of not having a 50-50 split. As Harvard Business Review study showed that venture capitalist firms are less likely to invest in companies owned 50-50. So there are some stories about this, and the Harvard Business Review walks through them. But one of the main things is, if you're not a 50-50 split, it shows that you had these difficult conversations up front, which can show a venture capitalist firm or whoever else is potentially investing in your company that you're able and willing to have difficult conversations, and you could work through some big issues from the forefront. It shows that you're well prepared. So another way to divide equity is based on your contributions. So you can think about what each person is contributing to your business, which you can consider using an equity calculator, which many are available online. And one good example of that is founders.com, which is UNDRS.com. So those equity calculators will ask you a lot of questions about your business and how much each co-founder is contributing to that business and how crucial of a member they are. And it'll give you some insight as to how to develop and how to dole out that equity. So once you do give equity, the next bullet point talks about vesting provisions. So when you give equity, you should consider using vesting provisions, which means that each founder gets a % of the company, but has to earn it over time. And that time period is typically 4 years. The way to earn this equity is just to remain involved in the startup, or if you reach certain performance milestones. So this allows the company to prevent a co-founder from getting a free ride by leaving the company with, say, 50% of the company 6 months after it was launched. Co-founders often leave a startup in the early stages, such as in the case of a startup that's formed by college students. One might decide to go to law school, or if it's a medical startup, they might decide to go to medical school, and they might not longer have time to work on that startup. So this vesting provision can stop them from that free riding problem where people own part of your company but are no longer contributing. The other thing to think about is venture capitalists and angel investors typically expect co-founders to be subject to vesting. So sometimes it's best to have the conversation among you and your co-founders up front so that a stricter vesting provision is not put on you later on once you do get that equity or that investment from a venture capitalist or an angel. So if you do decide to use vesting, it's important to consider something called an 83B election to get certain tax advantages. We really don't have time to explain the details now, but we wanted to flag that and encourage you to consult an accountant or a lawyer for further guidance if applicable. So that 83B election is very important if you decide to go through with vesting. So the third bullet point here is buyback provisions. So you want to think about what you want to have happen to a co-founder's stake in the company if he decides to leave the company. So typically, starters want the right to buy back equity from a departing co-founder so that the company remains closely held. So they don't want departed employees to continue to hold that equity once they leave. So the company will have the right to buy it back. But you also have to consider how these buyback provisions will interact with any vesting provisions. So typically, equity owners would forfeit any unvested equity, but the company would want the right to buy back the vested portion of the equity. So to explain that a bit more clearly, if that person does leave, and if they have, say, a 4-year vesting time period and they leave after 2 years, they'll get their 2 years worth vested, and the 2 years that they left early for would be unvested. So the company would have them forfeit any unvested equity, but would want to buy back that 2 years of vested equity. And the other consideration with the buyback provision is to consider what the price of the buyback should be. So it's sometimes fair market value determined by an appraiser or in the company's discretion, but these are conversations that you would need to discuss further and flesh out in whatever agreement you decide to put the vesting and the buyback provisions into. So we know that these are very complex topics, so companies often wait to decide these types of details until they've formed and launched the company and have consulted with a lawyer. But hopefully, because you're here and because you're being proactive and listening to us today, you'll have some sort of an idea to be proactive, and then you can be on the forefront and address these later on when they do come up and do get a little bit more complicated. Okay, so the next is choosing a name for protecting intellectual property. So Blair and Allie will be discussing that for you all.
Thanks, Greg. Hi, everyone. My name is Blair, and I'm going to discuss the first half of the next topic, which Greg already mentioned, is choosing a name and how to protect your intellectual property. So intellectual property is commonly referred to as IP for short, and it generally means any product of the human intellect that the law protects from unauthorized use by others. So this is basically the body of law that protects creations of the mind through patents, which are rights for novel and useful inventions, trademarks, which are rights relating to the branding of goods and services, which we'll be discussing more in depth shortly, and copyrights, which are rights for tangible expressions of ideas, such as art or software coding, And lastly, there's trade secrets, which are rights for unique and valuable intangible assets, such as procedures or a formula. So as you can see, IP can be one of the most valuable assets to a startup, whether it be a patent on an innovative technology or a copyright for original material. So it is important to consider all of the IP you have and how to protect it. But for now, on the next slide, we are going to discuss choosing a name. All right, so one of the first things entrepreneurs need to do is choose a name for their business. Most entrepreneurs will focus on business considerations, like whether the domain name is available for their website, what the search engine optimization will be, which looks at how high up in Google searches the desired name will appear. And then lastly, whether the name will be appealing to consumers. However, savvy entrepreneurs will also think about legal issues before choosing a name and will try to choose a unique name. So to be a part of the savvy group, you should search first the Department of State website, secondly, the USPTO website, and third, Google or your preferred search engine to search for the name you are interested in or names confusingly similar to your prospective names. So to provide a little more detail on this process, first, no, go back, please. So first, you'll eventually be forming a legal entity, and you need to determine if the name you want is already taken by another legal entity. So you could determine this by going on the Secretary of State website. And to do this, you can Google New York Business Entity Search to find that website where you can search for other business entities. And as you're doing this, keep in mind that your company name has to be distinctive from other entities already registered. And there is no guarantee that you will get the name you want, and you won't really know for sure until you register for that entity. So it's probably a good idea to have some options. So secondly, you're going to do a Google search to see if the name is in use by another company. You may come across a company that has the name you're interested in, but it wasn't registered with the New York Department of State, or maybe it was registered with another state, or maybe just not registered at all. So it's really important to do this Google search to see if anybody has been using their name commercially in another space, and just determine if they are using that name, what industry they're in. Perhaps they will be operating in a different industry than you will be in. So next you'll do a USPTO search, which stands for the United States Patent and Trademark Office. And you'll go on this website to determine if someone has already registered a federal trademark for the name you want, or a confusingly similar name. So again, trademarks protect things like logos, names, symbols, and slogans. And every business has a name and a brand associated with that name. So the trademark is an issue that all entrepreneurs should consider and take note of as they're in your early stages. So again, searching for trademarks is important because you don't want to choose a name and spend time and money developing a brand and your customer base only to find out that you're infringing on someone else's trademark, or you can't even get a trademark to protect your own brand. So this is a mistake that a lot of entrepreneurs make, and then they have to spend a lot of time and money to rebrand. And you can consult an attorney to help conduct a trademark search. The USPTO website can be a little bit tricky, but there are a lot of helpful guides on the USPTO website that can help you with this search. And then in addition to determining if any trademarks already exist for the names you're interested in, you should consider whether the name you want to use is eligible for a trademark, as will be discussed in the next slide. Okay, so as you develop your name, you will want to protect the brand associated with that name. And to protect your brand, just don't choose a name that infringes on someone else's trademark, and consider registering your trademark. So there are three types of trademarks, that you should be aware of. First are common law trademarks. And with these, you automatically get common law rights by commercially using a trademark within a given territory. So if you're in New York, your rights would be in New York. So common law gives you the right to prevent others from using in your territory of use, again, the same or similar mark for the same or similar goods or services in a way that is likely to cause consumer confusion. So this means one can have common law rights even if the mark is not registered on the USPTO website or within the state. And And as you can see on the slide, these unregistered common law marks are typically designated with the TM symbol or SM, which are for service marks. And technically service marks are for services and trademarks are for goods, but people use both pretty loosely. Secondly, there's also state trademarks. So some entrepreneurs decide to register their trademark within the state they're operating in if they don't expect to be operating nationwide. And then lastly, as we already kind of discussed a little bit, there's federal marks. So entrepreneurs who want nationwide protection can apply to the USPTO to get a federally registered trademark. And once you do this, you can use that symbol on the slide there, the R in the circle. And federal registration actually provides a lot of benefits, but just a few. It provides constructive notice to the public of your claim to the mark and a presumption of ownership. So this presumption basically means that you have exclusive rights to use the mark nationwide in connection with the goods or services specified in the registration. And on the next slide, Ali Shapiro is going to be talking a little bit more about trademark registration.
Hi.
And, Blair and Ali, as part of this, a question has arisen.
Yeah, I saw that.
Okay, so maybe you can incorporate that into your response, and Professor Lezepnik will jump in if he has additional thoughts as well.
Definitely. Hi, I'm Ali. As Blair mentioned, I'll be discussing a couple more points about IP. So first off, for trademark registration, there are a couple of factors to consider. As Blair mentioned, you should first consider if the name is even available for your company for a federal trademark registration by searching the USPTO website. And then after you discover whether it's available on the website, once you search, it shows you people who have either registered the name. You can search, just simple words to see how people use that word that you're thinking of in your company names, things of that nature. But once you do that step, it's really important for your name to be distinctive. And I think this touches on the question that someone posed in the chat. So there is a spectrum of distinctiveness. And the goal is to be as far to the right as possible, which is fanciful. So you want to try to choose a name that's fanciful, arbitrary, or suggestive of the product or service without merely describing it. You don't want to choose a generic name. And just to give a couple examples to, I think this would be helpful. Arbitrary is something as like apple. Apple, although it's a word that you use to describe fruit, in the situation of the company, it's for computers. So that's considered arbitrary. Fanciful, an example would be something like Pepsi or Venmo. They're just made up words that otherwise have no meaning. Something that's suggestive, the word or mark in the product, but there's some type of imagination to determine that connection. So there's a connection, but it's not totally obvious. For descriptive, there's more an obvious connection. So something like cold and creamy to describe ice cream, that wouldn't be the best name choice because, it does describe the product or good that you're trying to sell. And then lastly, a generic name is just a name that a marker word that connotes the category of the product rather than the brand or the source. So it can either be generic beforehand or it can become a generic term. So things like Kleenex or thermos, Kleenex, really tries to make sure that it's not considered generic by monitoring their mark, but thermos at this point, although it describes a water bottle, a lot of people have just incorporated it into their daily language, and therefore it's become generic and is no longer a trademark. So I hope that touches on your question a little bit. In regard to the foreign language, I'm not exactly sure how that works. I would assume it kind of works in the same way on that spectrum. Maybe Professor Lebesnik can talk to a little bit more, but
sure, I can just very quickly, here in America, we don't have an official language, even though most of it, most of us think of it as English. We don't actually have an official language. So any language where that word would be considered descriptive within that language or generic within that language is not something that you can register as a trademark. It has to be fanciful or arbitrary in that language as well. So if you pick, for instance, the word for alcohol in Japanese and try to make that into a mark here in America that is still considered generic for the USPTO.
Thank you. Yeah, so we can go to the next slide. Thanks, Greg. So how to ensure company ownership. In addition to trademarks, IP includes patent and copyright. We don't have time to cover them in depth, but the key takeaway is that you want to ensure that the company, rather than the workers or the employer, if they have a day job, obtains ownership of the IP relating to the company. So a rule of thumb to remember, as seen in the slide, is that if you want the company to own the IP, get it in writing. This is typically done by having workers sign a confidentiality and inventions assignment agreement. And it's really important to do your due diligence. And this goes to finding out if your workforce is subject to any IP assignment provisions in their day jobs. For example, if they're working a day job at a biotech company and are moonlighting at your biotech startup, it's possible that their day job had them sign a document that says all work they do relating to the biotech industry, even if done outside of work, belongs to the company. Sometimes these agreements have tails, meaning that they require former employees to continue to assign IP in anything related to the former job for a certain number of months after they leave the employer, although whether or not that's enforceable depends on a number of factors. So it's really just important to keep in mind that you do a lot of diligence on your workforce to ensure that any IP that they are creating, is a part of your new startup company. So how to protect your inventions. So a quick overview for patents. Patents protect useful inventions that are novel and non-obvious. To get a patent, you have to apply to the USPTO and make certain disclosures. For novel, it's a pretty low bar. It just has to be something new. But for non-obvious, it's a bit more of a strenuous requirement. And that's something that you should probably consult an attorney for. But it just can't be like a chair in black would be a black chair. That wouldn't qualify as something that's not, that would be considered obvious. And then for trade secrets, some companies instead choose to keep their inventions secret and rely on the trade secret protection instead of getting patents. So trade secrets were involved in a case where you might have heard about, where an engineer was charged with stealing trade secrets about the self-driving car technology from Waymo, which is Google's self-driving car project, and using them at Uber when he left Waymo to work for Uber. So overall, if you have an invention that's patentable, it's important to consult a patent attorney for further advice and to develop an IP strategy. You want to consult a patent lawyer early on because an inventor must file for patent protection within 1 year from disclosure of the invention. And you should definitely look into what constitutes disclosure, because that also has a large array of requirements to what is considered disclosure. And patent law is a specialized area of law that this clinic does not cover. The IP clinic does that a little bit more. So yeah. That's it. Thank you.
Hi, everyone. My name's Rob Dominiak, and I will be talking about liability protection as our third issue of the clinic here. Protecting against liability it's an extremely important step for entrepreneurs. You always want to take measures to protect yourself, and there are a few ways to do it. If you don't, you can end up in a litigation that's very time consuming, that's expensive, and can actually prohibit you from starting up your company. And so it's always important to make sure you're always protected against any harm or loss from someone who uses your product or service. So okay, next slide, Greg. Thanks. So here are how to protect against liability. There's three main ways we've encountered, and one's forming a legal entity. And what this does is, pretty much under the law, a legal entity is considered a separate person. So you will pretty much be insulated from any losses or lawsuits, and a separate person or the entity will in fact be liable if anything comes up. Another way is to enter into contracts with protective language. For example, if you are running a website or create an app, you would have to have some terms of use with some disclaimer policies that kind of, explain that the user is liable on his own and on her own, and that the company will be held harmless from any damages that he or she may suffer from again using the product or service. You should also have some privacy policies on your website, which specifies exactly how you, the business owner, will use all the data gathered by, whether it's emails or names entered into the website, or electronically computer or phone data that's somehow collected. It's always good to be forthright and protect yourself in that way. You can also enter, you could also have indemnification provisions in contracts, which kind of shift the risk from yourself to the user of your product. And these are, negotiated points, but any losses or harms can kind of be shifted off yourself. And, these are generally, like I said, negotiated points. I think it would be wise to, use an attorney to go over these contracts to make sure that you are protected. The law is constantly changing. Business law is changing, and as things evolve. So, and also just to make sure you're in compliance in your business, because you could be putting some information or in these terms that aren't completely comprehensive of your business. And especially if you're in a high risk industry, it's important that you touch all the bases to make sure you're fully protected. So advising attorney is always a smart option. The last option is purchasing business liability insurance. This just adds another layer of protection. It's kind of like a backstop to the prior two that I just talked about. It's kind of like a catch-all where, if litigators are good at finding holes in language and contracts, and this is just a way, just another layer to protect yourself from, something that may not be covered or can be somewhat ambiguous in a contract. So, okay, next slide, Greg. So why form a legal entity? The main principal reason is you want to protect your personal assets from liability. If you operate a business on your own, you create a sole proprietorship, which will make you completely liable for anything that goes wrong. If you create a business with a co-founder, you create a partnership, and you both will equally be liable for any losses or harms done. So like I mentioned before, a legal entity is considered like a separate person. So by forming that, you kind of isolate or insulate yourself from your personal assets. And even though most students may not have tons of assets like a house or whatnot, your bank account, car, any trust funds can be taken if the company gets sued. So you must, to protect your assets, it's very smart to set up a legal entity. Once you do set up the legal entity, you must operate the business properly. This means all contracts should be signed in the legal entity name, not your own personal name. If you happen to form a corporation, not an LLC, you must follow corporate formalities. This means keeping good books, keeping meeting minutes, having board meetings, paying taxes, and not commingling funds. So pretty much having your personal bank account separate from your business bank account. Otherwise, if you do not keep these formalities, the courts in a lawsuit can what's known as pierce the corporate veil, which is pretty much go after your personal assets, which would usually be protected by having a legal entity. So, and the next slide talks about just types of entities that you should be thinking about if you'd like to form. You have for-profit entities, which my colleague will be getting into, which covers LLCs and corporations. Hybrid entities, which are for-profit but have a charitable goal and in mind, and then you have your nonprofits. So it's best to, decide what kind of entity you are and kind of which category you fall in. Typically, student entrepreneurs form LLCs or corporations. So those are just definitely, that's probably where you'd want to start thinking about things. And my colleague Eric will now talk about various LLCs and corporations.
Thank you, Rob. I'm Eric, and today I'm going to be talking about how to choose your business entity. As you can see here, there are several factors on the slide. One of the key factors I want to talk about is taxation. One of the drawbacks of forming a corporation is that there is double taxation. And what that means is that a corporation has to pay tax on any profits it makes, and then shareholders have to pay tax on any dividends they receive from the corporation. So that can be onerous for some people, but it's not as onerous as it seems for several reasons. One of them being is that under recent tax law, a change in tax law, the corporate rate has lowered significantly from 35% to 21%. Furthermore, many startups aren't profitable for a while. And even if they are, they often choose to retain their earnings rather than distribute them as dividends to the shareholders. People who hold equity in C corporations with gross assets that do not exceed $50 million get certain tax advantages if they hold stock for at least 5 years. This essentially allows them to be exempt from paying any capital gains tax when they sell their stock. So that's subject to certain exclusions, but that's called qualified small business stock, which is very attractive for many investors. Corporations can also choose to become S corporations rather than the default, which is C corporations. By becoming S corp, the company is only subject to one level of tax at the shareholder level. One thing to keep in mind, though, is that New York City does not recognize this, so you still have to pay a New York City tax. Another important factor for entity choice is financing. If you want to attract venture capital financing, creating a C corporation is typically advisable. Some investors prefer a Delaware C corp. Delaware has a specialized court that deals with corporate law issues, and that provides a certain amount of predictability with outcomes in that court. But the reality of the situation is that you have to keep in mind that less than 3% of companies are able to attract VC funding. And you would need to have a business model that is scalable and one that VC could exit and make a profit within a limited number of years. Most companies don't fit that description. And it's important to keep in mind that there are many other ways to raise money for your startup beyond VC financing, and that will be discussed a little bit later. So prepare a forecast to determine how much money you really need to launch and operate your business. So another important factor is administrative ease. Corporations have to have a board of directors and follow certain corporate housekeeping procedures, like having board meetings and keeping minutes. Many student entrepreneurs would prefer to avoid some of these formalities that the corporations have. So the default for most student entrepreneurs are LLCs, and they're often a very good choice for startups. LLCs don't have corporate formalities like we talked about previously. They're very flexible and easy to manage. Another benefit is that there's only one level of tax, unlike the double taxation with the corporation. And basically the owners are only taxed on their proportionate share of any profits that the company makes. Some of the cons are the publication requirement that New York requires. So it basically requires you to post ads in 2 newspapers for 6 weeks to alert the public that you formed an LLC. It can be expensive. It's from $600 to $1,200. and Manhattan's usually the most expensive. And also, as discussed before, VCs typically prefer to invest in C corporations. So it may be a better choice if you want to be attracted to VCs, or if you want to take part in some certain accelerator programs that require you to give common stock in exchange for your participation. So those are some of the cons of the LLC. With anything that we spoke today, consult a lawyer for further advice and an accountant to understand the tax implications for your decision of entity choice.
Okay, thanks, Rob and Eric. And a question has come up in the chat. Can you elaborate on the downside of forming the corporate entity and not following the formalities? So Greg, maybe you can quickly go back to the slide that has that corporate veil on it. And Rob, you can explain a bit more about what that means. What is piercing the corporate veil?
Okay. So piercing the corporate veil it pretty much means that the corporation is no longer acting separately from the business owners. Which when you do set up a corporation and do follow corporate formalities, any lawsuits or any loss or harms you're pretty much insulated from that as a person, your personal assets. Once you stop following the corporate formalities, you're pretty much lumped in together with the business, and your house, your car, or whatnot can be used as damages for, in a lawsuit.
Okay, great. Thank you. Okay, let's go on to the next topic.
Okay, so my name's Adam. I'm going to be talking about growing your workforce while you're cash strapped, along with my colleague Deanna. So I'll start us off the next slide. So the first question you have to decide is, as an entrepreneur, is how you want to classify your workers. So you basically have three options. As you see here, you have employee, which is the default, independent contractor, and interns. So you'll see that it's very typical for a lot of entrepreneurs who are just starting out, don't have a lot of money to pay employees, to bring people on and consider them interns without pay. So the real question is whether or not this is legal, and we're going to get into some of the requirements that you have to meet if you want to bring someone on as an intern, as well as if you want to bring someone on as an independent contractor. So basically, as I said, the default rule which is under the Fair Labor Standards Act is that anyone that you permit to work for you is deemed an employee. So obviously there are ways to kind of get around these rules and get exceptions from this default rule. And in order to do that, you would either have to establish, one, that you have properly set up an internship program, which again, we're going to discuss the details of, or two, that you are not exercising control over the manner in which the work gets done, and that's for independent contractors. So again, there are a lot of detailed rules that you have to kind of go that we would recommend, consulting an attorney to make sure that you're complying with each of these classifications. But we raise this because this has kind of become a very hot topic, especially given the rise of the gig economy. Companies like Uber and Lyft, there are big questions about whether the drivers for those companies and other gig workers should be classified as employees or independent contractors. And they're, again, because of the effect of this classification, this tends to be very consequential. So I guess we can move on to the next slide, and we're going to talk about, like I said, the effect of that classification. So again, the default rule is that these people that are working for a startup would be classified as employees, and being classified as an employee comes with certain benefits, especially in an expensive city like New York City. The minimum wage is $15 an hour, and employees are also eligible for overtime unless they meet a given exemption. So there's a big temptation for business owners to try to classify their workers as independent contractors or as interns if they want to pay them at all. But even in New York City, again, especially given the rise of the gig economy, and these big hot button issues, there have been laws that have been passed that give independent contractors certain rights as well. So in May 2017, the legislature passed a bill called the Freelance Isn't Free Act in New York City, which requires a written contract for independent contractors if they're being paid $800 or more. It also gives them protection from retaliation if they raise a claim, and it gives them the right to timely and full payment. So again, interns, as we're going to discuss in more detail, can be unpaid, but the company must show that it's kind of developed a real educational internship program, for the benefit of the intern rather than for the benefit of the company. So just to also kind of hit home why this classification is so important, there are a number of consequences that business owners face if they don't, if they misclassify someone who's working for them, and they include unpaid wages, back taxes, as well as penalties and interest. And just to show how seriously, the authorities kind of take this. On the federal side, the Department of Labor has kind of started this misclassification initiative where it reached, it has a memorandum of understanding with the IRS, which basically kind of just delegates the authority between the two agencies to go after employers who are misclassifying their employees. And on the state side, New York has formed this joint enforcement task force, which has staff from the New York Department of Labor, Attorney General's office, Department of Taxation and Finance, Workers' Compensation Board, New York City Comptroller's Office, a lot of different people who are really, dedicating their efforts to going after businesses who misclassify employees. So again, that's just to drive home the point that it's really important, if you're going as a business owner, if you're going to classify your workers as independent contractors or as interns, you have to do it the right way. So my colleague Deanna is going to go into some more detail on internship requirements, and let us know if you have any questions.
Thanks, Adam. Hi, it's nice to meet you all today via the video. So I'm just going to go over the few requirements that the New York State Department of Labor has laid out in order for-profit businesses to hire interns, for unpaid interns, as part of an educational component. And if anybody would like to look into these standards, they can search this online by just searching the New York State Department of Labor standards wage requirements for interns in for-profit businesses. So they go into more detail about these requirements, but I'll try and go over them right now. So first, the first requirement is that the training is like that provided in an educational program. So some of us might have seen or experienced that in a college or university setting where colleges or universities offer a externship for credit. That's one example of how this could apply. That's not required, but other examples could be that it builds on a classroom or academic experience. And it's just, it's a way that the internship kind of builds on what a student would be learning in college or any type of educational program. So the next requirement is that an intern has a primary beneficiary, is the primary beneficiary of the internship. So that fact is based on that the intern is benefiting more than the company is benefiting, and any benefit to the employer must be merely incidental. So the internship must focus on benefiting the intern over benefiting the company. The next requirement is that the intern does not displace any current employees in the business. So the intern should have, I guess, functions that are not similar to employees and is not similarly situated to any employees. Another way to demonstrate this is that the intern's form of supervision is different from employees. So the intern should have a supervision program and a training program that is different from any employees in the company. The next requirement is that there's no immediate advantage to the employers. So like I stated before, the immediate advantage has to be for the intern, and the operations may actually be impeded by having the intern there because they are learning along with the training process. The next requirement is that the intern is not promised any future employment post internship completion. So there should also be some type of fixed period that the internship lasts for. So interns who are placed with an employer for a trial period with the expectation that afterwards they would be hired as permanent employers, those would generally be considered employees. So it's important to denote that in your internship program that there is a fixed period, like a semester or a summer or a 6-month period that the internship lasts for. In addition, the student or trainee should be notified in advance of the program that they will not be receiving wages, and this notification must be done in writing. So this is an important requirement that is easy to comply with and demonstrate. So make sure that you demonstrate in writing when you offer the internship that you are not going to be paying wages. So this must be done before the internship or traineeship starts. In addition, the next requirement is that the intern is trained by people with knowledge and experience in the field within which the intern is working. So a way to demonstrate this is that the people and employees training the intern have background, education, or other types of experience that fulfill the educational goals and requirements of the training program. The next requirement is that the trainees or students do not receive any employee benefits. This would look like health or dental insurance, pension or retirement credits, or discounted or free goods and services from the employer. Next, the intern should be getting general training for the field. So this means basically that the work that the intern is doing is developing transferable skills that they can use in a future job opportunity. So the skills should be useful, transferable to any employer, like I stated, and not specific to the current employer. So nothing that can only be applied to this employment opportunity. And second to last, the next requirement is the screening for this internship must be different than the screening for other employment opportunities. So it's important when you are looking for interns to create a application and hiring process that would look different for employees when hiring employees. And similar to this factor, when you are soliciting for interns, you should solicit for interns in a way that is different than when you solicit for employees. So make sure in your ads that discuss this internship opportunity, you're discussing the training and educational components of the internship and not necessarily employment components. So make sure not to include any mentions of wages for the training, and so that there's no misunderstanding of the nature of the program. Can you go to the next slide, Greg? Thank you. So another thing that startups often wonder is, can they award equity to those working for them, and how can they do this? So as my colleague Adam stated, he had gone over the 3 different categories of employment for people working for and with your company. So if someone is an independent contractor, they can definitely be awarded equity in the business. So if they're properly classified, that would be no problem. Same goes for interns that are not being paid at the time, or even if they are being paid, they can also be awarded equity. Also, for example, advisors that may be working with the company as an independent contractor, they can also get a small amount of equity in the company. So for employees, it's a little bit different. So if anybody is paying employees minimum wage or above under state law, they must be receiving, basically, they must be following state law and federal law labor standards for pay, and then they can receive equity as pay in addition to that. Under federal law, there's a business owner's exemption that allows you to not pay employees if they own 20% or more of a business and they're actively engaged in the management of that business. However, under New York state law, the state law does not have that exemption under their law, so there is a risk of violating state law if you still don't pay your employee minimum wage. So if you're operating your business in New York, unfortunately, this federal law exception wouldn't apply to you.
So I'm Nate Chumley. I'm going to cover financing, the finance portion of this presentation. So financing is really the bedrock in regards to growing your business and paying your employees. Financing, as you know, with all the other topics we covered today, raises various legal issues. So if you go to the next slide. So this is the funding tree of financing. So the first one is personal funds. So just to get a little background, most entrepreneurs start at the bottom of this range of financing. So personal funds, it's the cheapest because you already have what you have. It's the most flexible, and most startups, as I said, bootstrap and self-fund in the early stage of your business. So the second one is friends and family. And again, this is pretty close to your own money. You have a close personal relationship with an entrepreneur. You know, your friends and your family don't want to exploit you. The time frame is more flexible. You know, the terms maybe longer, maybe a lower interest rate. And usually your friends and your family are not concerned with making a lot of money off of you. And so we can go to the next one. That's angel investors. These are high net worth individuals who might decide to invest in your business. Some have specific expertise in a certain industry, such as biotech. It's obviously more formal than with friends and family. There's less information typically provided to them than with formal investors, more formal investors, such as VCs or venture capital. Next one is crowdfunding. So this is sort of a more recent popular way to raise money for a startup, and we'll discuss this more in a later slide. Next one is banks and online lenders, so you might be able to get money from a bank or an online lender as a startup. That's a little more rare. They provide known costs, although certainty and predictability, those are benefits of banks and online lenders, but it's usually hard to get a bank loan if your business has no history of making any profit, for example. And you probably need to personally guarantee a loan, which involves your personal finances in the business. And the last one, the top of the tree, are VCs or VC funds. So many startups want to raise VC money from an institutional investor, so VC firm, but it's really very difficult to get. As we mentioned earlier, only about 3% or even lower get VC money, and they're only interested in certain high growth industries for the most part, like tech, biotech, for example, are two different industries that are high growth. And then furthermore, in this climate and during the coronavirus pandemic, some VCs are suspending or delaying investments until the business market becomes more stable. And then in terms of different types of VC firms, there's sort of niche and early stage VC firms that might have expertise in or prefer to invest in companies in particular industries, and they might invest in an earlier round, such like as early as angel investors would. And then there are later stage VC firms that bring more resources to establish startups. And again, as we mentioned, they're looking for really established businesses that will be able to scale and we'll have, you know, an IPO or go public and make money at that stage. So again, these are just some you know, faces you might have seen. Mark Cuban, a famous angel investor. Sequoia Capital, it's a famous VC firm. So you know, all of these types of investors can structure their investments as either debt, so like loans, or equity, which is ownership in the company, except for banks, which just give loans. So you can go to the next slide. So yeah, just to narrow into crowdfunding. So it's an emerged as a creative and easily accessible way to fund startups, and you know, more people can raise money through these types of platforms than, as I said earlier, with VCs or angels. So there's really two types. There's a reward-based, in which investors get rewards, like product samples, for example. And then there's equity-based, in which investors actually get the ownership interest in the company. So yeah, obviously, many of you may be familiar with Indiegogo or Kickstarter. Indiegogo, actually hadn't heard of them before this. They're the leading crowdfunder platform for tech products, as well as the only full lifecycle platform for art projects, social impact campaigns, and environmental innovation products. That's pretty cool. Projects, excuse me. And then Kickstarter, the general counsel is actually a Fordham Law grad. He's been featured on our Startup Law podcast, so you should take a listen to that. But they stated on the website, our mission is to help bring creative projects to life. We believe that art and creative expression is essential to a healthy environment in society, and the space to create it where it requires protection. They're actually a public benefit corporation, which is a for-profit company, but it prioritizes positive outcomes for society. So you know, it's a way to raise money. But to contrast, equity, you can only offer equity through equity-based crowdfunding. You cannot offer equity on platforms such as Kickstarter because they're not registered through the SEC. So yeah, in contrast to rewards-based crowdfunding, equity-based crowdfunding is available. This is it's a recent change in the law allowing the raising of offering equity through, it's called Reg CF, stands for crowdfunding. So you have to only use SEC registered intermediaries if you're offering equity. So they're a broker-dealer or a funding portal is what they're called. And you can find them on the SEC website, actually through Edgar, it's a search engine, or on FINRA, they have a list of all SEC registered crowdfunding platforms. And then one specific example of an equity-based crowdfunding site is Republic. It was started by a Gabelli grad, Fordham Business School grad. He's also featured on an episode of the podcast. So let's say you've attracted an angel investor and now need to figure out how to structure the investment. So there are two types of financing arrangements commonly used by angel investors or seed investors. So we'll go into convertible notes as well as SAFEs, which stand for it's a simple agreement for future equity. So convertible notes are loans that convert into equity. So they are debt. They convert at a specified future event, such as a qualified financing, which is, for example, a later round of funding above a certain dollar amount, 2, a sale of a company, or 3, when you've reached maturity date without conversion. As I said, it's debt, but it can be converted to equity. But technically, the goal is to get the note to convert into equity, and investors don't pull the trigger on conversion. They want to see the company grow, and yeah. So the equity can convert into what is called preferred shares. It's a type of ownership that gives the shareholders certain additional rights, for example, to elect certain number of directors, receive fixed dividend payments, which are not available to common shareholders. It accrues interest. It's about 4 to 8% in a typical convertible note, and has a repayment date typically of 1 to 2 years. But they're often, as I said, left outstanding if the maturity date arrives and they haven't converted into equity yet, or the parties can renegotiate an extension. And the benefits to the company for convertible notes is it lets the company get investment while avoiding the need to value at an early stage. Usually companies don't have a profit flow, and it's very hard to value a company at a very early stage. And the benefit to the note holders are they get a reward for taking on a risk in funding a new venture by receiving a convertible note. You can cap the valuation at a certain amount, which means if the company hits it really big, like Uber, for example, and you're a convertible note investor, and it's valued at $1 billion, your value cap will be much lower than that. Also, you can have a discount rate, which is common, which is at that equity. Equity financing time of the conversion at the end, you'll get a discount, either 10 to 30% of what the company's valued at that time. So again, these are a lot more simple. They were created by Y Combinator. It's a pretty famous accelerator. They don't accrue interest. They're not debt. They're a good alternative when companies are concerned if they may reach the maturity date without having an equity financing round. But tax treatment of safes is uncertain. And then just as an anecdote, Donna Riddell, a board member of New York Angels, who came to one of my other classes, says that they don't use safes because there's not really as much of a backstop as convertible notes, because it's not tied to the assets of the company like debt would be. It's more of a promise to give equity in the end. So you can go to the next slide. Just as a disclaimer, securities law is very complex, and you can get into a lot of trouble if you don't do it right. So you need to consult a lawyer before issuing any equity, because there's complex rules in the federal and state level as well. So that's all I have. I'll pass it along to Greg.
Great. So hopefully you guys all have a better understanding and a better sense of these top 5 legal issues that affect entrepreneurs such as yourself. So here are some other resources that you guys can check out. So feel free to look these up, and you could go to our clinic's website, which you see there. You could check out the Penn Law Startup Kit, and also Up Counsel is a great resource for you all. So Up Counsel allows you to hire experienced lawyers on demand at reasonable prices, and it's project-based work rather than retaining a full law firm. So we've also listed various other online platforms that could help you form your company, but just keep in mind that these platforms don't advise you on the law, but they just help you complete legal tasks as you go along. And also, as Nate mentioned several times, you should check out our podcast at Startup Launchpad. We cover all of the topics today that we discussed in greater detail, as well as many other legal topics that would affect entrepreneurs such as yourselves. And It's available on Apple Podcasts, Spotify, and startuplaunchpad.org, or you could just Google Fordham Law Entrepreneurship Podcast to find it. So we do want to thank you all and appreciate you coming and listening. And now we'll open the floor to any questions. So you could feel free to keep using the chat, as I saw many of you were using already, or use the hand raise function, and we'll try to get to you and address this. So we have one question in the chat. I think Nate, you could say this is about convertible notes.
Yeah, so Maria asked, if we do a convertible note and investors want to convert into equity at the next round, then does the interest also get considered in converting into equity? Or is the interest only for when the investor does not want to convert into equity? So I think it has to do with the terms of the convertible note, but usually the outstanding interest also gets converted into equity. Correct me if I'm wrong, but that's what my research has found.
Yes, that's correct. Usually the interest sort of accrues as the note is ongoing, and then if and when the conversion happens, the interest that has accrued converts along with the principal of the note into preferred equity of the company. So yes, that's correct. And Deanna, your response to the question about the internship, that was correct as well. As long as you are complying with the minimum wage requirements, you do not need to comply with the unpaid internship requirements. And there are some lawyers who will advise entrepreneurs that all interns who you all hire should in fact be paid minimum wage. You know, the reality is for student entrepreneurs, often you all don't have access to money to pay unpaid interns. So that's why Deanna focused on what would be required to have a properly structured educational internship program. Okay, Al Bartosik, you raised some great points about the Fordham Angel Fund and crowdfunding. Would you like to say a few words about that?
Sure, and Jody has a question. She nicely raised her hand, so I'll just say a couple of things and then we'll go to Jody. So Fordham's got a couple of funding options that I think everybody's aware of, but just wanted to reiterate in this forum. So one, Fordham has established the Fordham Angel Fund, which will invest up to $25,000 in the form of a convertible note, and only in the form of a convertible note for the reasons that were alluded to earlier. And just interesting to note that Donna Riddell is on the investment committee of the Fordham Angel Fund. So if anybody comes and applies for funding, you will meet Donna that way potentially as well. So I would encourage, if somebody is a current Fordham student and does want to pursue that avenue to be able to have an investment in their company, that they can go to the Fordham website to find a Fordham Angel Fellow at the Foundry website, or they can just email me directly. And the other thing I just wanted to briefly mention is that Fordham also has a crowdfunding site if you meet certain criteria, and I posted it in the chat. The big advantage for that is that they don't take a fee. So Indiegogo and Republic and all the other sort of forums that were mentioned are out there make their economics by taking a fee from the crowdfunding. So if you do qualify, it's a great resource to be able to use and keeps more money in the company as you move forward.
Okay, great. And there was a hand raised. Jody.
Can you hear me?
Yes, we can hear you.
Okay. I mean, there's a lot of stuff that goes into starting a business successfully, and a lot of it is legal. What is a reasonable amount for a person to expect to pay, or a startup to expect to pay in terms of legal fees for a startup?
Well, you know, it really depends. You know, first, if you're able to get into a free legal clinic like the one that, you know, we have here at Fordham, that obviously dramatically decreases the expenses. Most entrepreneurs are not able to do that, so they try to work with a smaller law firm that might have a lower cost structure than some of the larger firms. But many of the larger firms now have special programs where they have reduced rates for early stage entrepreneurs, with the hope that eventually the entrepreneur will, you know, be successful and be larger and be able to attract some venture capital funding, for which the law firm can charge their market rate rates. So, but most entrepreneurs end up, as I said, going with maybe a solo practitioner or a small law firm who's able to work with them at lower rates. The website that Greg mentioned, Up Counsel, is a really great resource that connects small business owners to lawyers on demand who will only charge for the particular project on which they're working. But the rates for lawyers can be quite high. Even, smaller firms may charge a couple $100s per hour, and certainly the large law firms, can charge $600 and up per hour. So because of that, a lot of people, as I said, are going to smaller firms, or they're using platforms. So again, Greg had a screen where he showed a few platforms like Shoebox and Cooligo and others, where many people are now sort of doing it themselves using these platforms, and that can dramatically reduce their costs.
So while you guys are thinking up your next question, I just want to follow up on something that Allison said regarding patents. She noted that here in the US, we do give a 1-year grace period from when you come up with your invention to when you file your invention. But the US is actually one of only a few countries that does that. Most countries don't give that kind of grace period, and anything you do in the US can actually prevent you from getting a patent in those countries. So if you're thinking that you want to go global eventually, you want to keep your invention secret until that patent is filed, you want to have a non-disclosure agreement with people you discuss the invention. And a common example of that is, if you're planning on producing your materials in India or China, if you're planning on selling ultimately in Europe, all those places do not have a grace period for filing of a patent.
Okay, thank you. So what other questions do you all have? As I said, we want to make this as relevant as possible for you. So if you have questions, we're happy to jump in and answer them. And while you all are thinking of our questions, if any of my advisory board members would like to say a few words or provide any guidance or other perspective, you can feel free as well. I saw that we had Bob Nolan on the line. It looks like he may have had to have jumped off, but he has a lot of experience in financing and private equity. And we have Alexis Clemish, who has a lot of experience with privacy law, IP, business law, and tech transactions. So if either of you have any thoughts, of course, feel free to jump in.
It looks like Ashkath's got a question, Bernice, also.
Okay. So how far do the protections for copyright/trademarks filed in the US go when online? Professor Lizebnik, would you like to take that one?
Sure. I thought you were going to give it to, did Blair have to?
Well, yes, I should allow the students to answer first if they'd like to attempt to. So Blair, actually, one of the students who focused on IP, unfortunately had a class commitment, so she had to jump off the line. But I think Ali is still here. So if Ali, if you want to take a stab at this, if not.
No pressure, Ali.
I think that it's different per country, right? I don't think just because you register something in the US doesn't mean that you have international rights. I think that like trademarks specifically, if you get or if you acquire goodwill to a certain extent, then that trademark possibly through common law could have trademark protections, but otherwise with patents and like trade secrets, did you say? You could go to uspto.com. That's like the patent search tool. But Professor, I think you probably have a better idea. I took IP, but I only learned really about like national laws, not international laws. So you might be better equipped to answer the question.
No problem. So with regard, I'll split it up because copyrights and trademarks are actually treated somewhat differently when we look at the international landscape. Because of certain international treaties we've signed on to here in the US, your copyright here in the US is actually recognized in almost every other country in the world without you having to do anything. But to enforce it in that country, you would still have to go to their court, but they will recognize your rights based on your US copyright rights. On the trademark side, it is slightly different. We provide a mechanism here in the US through international treaties to more easily let you register it in other countries, but ultimately it is based on your using that mark in that country, just like your rights here for trademark rights in the US are based ultimately on your using the mark in connection with goods or services. So there is a way to claim priority to a trademark by filing here in the United States for countries abroad, but to enforce those rights in those other countries, you do have to actually start using the trademarks in those countries as well. I think I saw another question about patents. Do you know of any patent search tools? There was a company, Loci.io, that used to exist but is now down. So it's a double-edged sword, actually, to start searching for patents. It is a good idea if you don't plan on patenting your invention to do the searching yourself. It is a bad idea if you are planning to do to potentially patent it. And the reason for that is here in the US, you as the inventor have an obligation to let the USPTO know of any potentially relevant article or thesis or patent that is close to what you are trying to patent. You have an affirmative duty to disclose that to the USPTO. So the more you use Google or whatever you want to search for patents that already exist that relate to your invention, the more of those you are going to have to end up showing the patent examiner. It's better to hire a vendor and to consult an attorney to help you with that search if you want to do it. So the simplest search tool you can use is actually Google itself. If you Google patents, the word Google patents, Google will take you to a special search tool they have to search the USPTO's patent database. It does contain other ones, but as I said, be cautious about that. You know, there have been inventors who ultimately lost their patent because they did not disclose everything they knew that had existed when they filed for a patent themselves. So be very careful about that.
Okay, what other questions do you all have? I know we threw a lot of information at you. It's a lot to digest, but we wanted to try to give a sort of a survey overview of a lot of the issues that frankly come up in our clinic on a regular basis.
I think we've got time for one more. I've almost got 6:30, so it looks like Emily's got a question here.
Yes, so when deciding whether to turn your LLC to either a for-profit business, nonprofit, or hybrid, what are the potential benefits of establishing a hybrid structure? What are some of the drawbacks? Any sources you recommend to look into further? Rob, do you want to try to take a stab at this one? I think you covered this topic.
Yeah, I could give it a shot. So I know, well, some potential benefits of a hybrid structure. Well, hybrid structure deals with, you know, you have to be for profit, but also, you know, you act like as a nonprofit organization in terms of, you know, your goal is to, you know, further. So what are some drawbacks? I'm not positive as far as how they are taxed.
Sure, and I know we didn't cover this too much in class, so I can jump in here. So the sort of genesis of the hybrid corporation is that there's, as you know, been this movement towards companies wanting to have a positive social impact, right? So they want to do well, but also do good. They want to do positive things for society. And under corporate law, there's a question as to whether or not that is permissible, given that historically the corporation was supposed to maximize shareholder return. And so the question is it okay for companies, for corporations to have these other sort of public interest goals, if that might create some tension with their requirement under corporate law to maximize shareholder return. So this thing called the benefit corporation has arisen in response to that. And the benefit corporation is one in which it is a for-profit entity, but the company hardwires into its charter its goal of creating a positive public impact. And in terms of the sort of benefits / drawbacks, so one of the benefits is it addresses that potential, you know, concern that some people who wanted to bake in positive social impact may have had, although studies show that companies that have positive social impact actually in many cases do just as well, if not better, than those that don't have those missions. But setting that aside, in terms of other potential positives or drawbacks, Another issue is financing. So there's been a lot of funds that have launched that are social impact funds that are looking to invest in companies that want to do positive things for society. So by creating yourself as a benefit corporation, you may become more attractive to those kind of funds. That being said, there's other ways to do that from a marketing standpoint without formally creating a legal structure as a benefit corporation. So we typically advise startups not to focus too much on being a benefit corporation. You can just be a regular corporation or LLC and still have these sort of social impact positive goals, as long as you stay focused on also generating a positive return for your investors. So that's a few thoughts to keep in mind about benefit corporations.
And maybe you could just clear up a little confusion that I know people have from time to time that have come to us, the difference between a B Corp and a benefits corp.
Yes, so that is a very confusing issue because the names are so similar. So what Rob and I were just talking about is what is called a benefit corporation, which is an actual legal entity where you can create your company and make it a benefit corporation as opposed to a C corporation or a limited liability company. Now, separately, there is something called the B Corp, and that is not a legal entity. All it is really a seal of approval, like a stamp, that you can get from a nonprofit organization called B Labs. And that seal of approval basically means that regardless of what kind of legal structure you have, you are meeting certain goals to have a positive social impact. Now, the reality is many companies decide to do both. They may decide to be a benefit corporation and get certified by B Lab, so it makes it very confusing. And I think in some states, the only way to really qualify is to kind of do both. But technically they're distinct. The benefit corporation is a legal entity that you can form, whereas the B Corp is really just like a seal of approval that you can get. And in either case, you can use it for marketing reasons to show your potential customers that you are interested in creating a positive social impact. Okay, so it's 6:32. I don't see any other questions in the chat. I don't see any other hands raised. Do any of my advisory board members want to say a few words? I just want to give you the chance if you did want to before we end the session. Alexis.
Hi, Professor Grant. It's Alexis.
Hi.
Hi. I would just say to the questions about, finding legal resources, and since when you do start your company, it does require a lot of help. And so I would say more and more in Silicon Valley, where I am in San Francisco, but I'm sure it will become larger over time. There's a lot of new firms popping up that are distributed firms, and there's sort of new entrepreneurial business models of how to create law firms of folks like myself who are companies like Twitter and who practice in an entrepreneurial way where they are able to be more flexible with rates. And I was at Cooley, so I'm used to those big firm rates as well. But I would just say the best way to, because I think it's a great idea to get early on legal advice, because I think there's a lot of complication when you first start your business. So I would just say network with the folks that you meet on this on this forum, like this opportunity, but also network with people that you trust and who are lawyers or who have started companies, and they can usually find you the right resource, whether it's Cooley Go or whether it's an attorney that's practicing on their own, or whether it's a platform or resource at a solo practitioner or someone who's been in the business for a very long time but has their own practice. So there are a lot of entrepreneurial ways to find really helpful attorneys that really want to help business succeed. And so I would just encourage you to keep networking, because you can usually find someone, you want to find someone you trust, because sometimes you get what you pay for, and so you want to be careful. But if you're careful, I would just say, just like you're doing on this forum, network and talk to as many people as you know and find someone you trust, because I know it can be a daunting proposition when you first start out, and so you should always feel comfortable to ask people that you know, and ask lawyers that even at big firms, they can generally find you someone who can help you, and it's really important to get the help you need when you're first starting out.
Great, thanks so much, Alexis. Okay, so Al, do you have any final words you'd like to add?
I just wanted to thank you and Ron and all the members of the Entrepreneurial Law Clinic for spending some time with us. Hopefully our entrepreneurs found this to be useful. I always find it to be a great exercise, because law is, and I'm an accountant, I'm a recovering accountant. So law and accounting go hand in hand in the world of entrepreneurship. Nobody needs us until they need us, and by then it's too late. So I am hoping that this has given some folks some food for thought, and understanding that it's really better to get professional advisors. And as Alexis said, you get what you pay for sometimes. So I will say competent professional advisors involved with your startup companies as you move forward. And the Foundry is a great resource in terms of trying to direct you to folks like that. For those of you that want to learn more about the Entrepreneurial Law Clinic, I encourage you to do so. They have, I believe you have a website, is that right? Or you have a link?
Yeah. Yes, we do.
So you can find them that way. But again, I'd like to thank you all for the afternoon, and this has been recorded. So we will be posting this on the Foundry website as a link. So for those of you who would like to go back and take a look at some of the answers, that's great. And I think maybe if you want to give the disclaimer one more time that this is not intended to be legal advice in any way, shape, or form.
Yes, that is. It really is just an educational workshop, but we hope this has made you smarter about a variety of legal issues. And if you are interested in applying to the clinic to become a client, of course, we're happy to review your application. We'll be taking on new clients in September when the new semester comes on board. Unfortunately, we will no longer have these current students. They'll all be graduating and moving on to law firms, but I have a new crop of students coming in who are hungry to get going with working with some new clients. Okay, well, thank you all for your participation. Great job to my students, and all the best to the entrepreneurs with your business ideas.
Thank you. Bye-bye.
Bye-bye.